Welcome back to the Wealth Builder podcast. I'm your host, Nick Donato, financial advisor at Guidance Financial. Property always seems to be a big talking point with a lot of our clients here. This has been further compounded lately, I feel, with supply issues, interest rate hikes, and the recent budget that was meant to give younger Australians a leg up in the housing market. At the end of the day, even if there is help provided, it's not a simple task to break into the property market. So we are seeing more and more that we're leaning on family to assist and the old bank of mum and dad. While we don't want to be negative and think about family and relationship breakdowns, it does happen and it can happen. There was an article in the Australian Financial Review recently which discussed real life cases which further highlighted some disasters that can arise. So today with Paul Benson, we'll be reviewing this article and discussing each of the cases raised. So let's jump into it. Thanks for joining me today, Paul. Thanks for coming on.
Hey, no worries, Nick. I came across this article in the Fin Review. It was published the 9th of July, 2026, for anyone that might want to have a bit of a look. But yeah, it's quite an interesting one about situations where family support, and it's not always mum and dad actually in these articles, but family support was provided in terms of property transactions, which, as you say, Nick, comes up a lot, doesn't it, between the clients that we work with? And there's five cases here, and I just thought they were really varied and really interesting, and thought it might be worth you and I sort of tossing around and sharing with the financial autonomy community.
Yeah, there's definitely a few lessons to learn and a couple of things that might have surprised you or you wouldn't have thought of in these scenarios. So yeah, there's definitely some interesting ones in there.
Yeah, totally. Well, look, we've got five cases, so maybe do you want to lead off with the first one?
Yeah, so the first one, Han versus Han. So there wasn't an issue in this one between mum and dad and child. The issue actually arose when the son got his spouse involved. So what happened was the parents lent him $4.7 million before he got married.
Did they, Nick? Did they? Because some of the document there says they only could provide documentation for 1.9 million. So I thought that was an interesting element. But yeah, by the time it all went to poo, they were claiming nearly 4.7, weren't they? So
Yeah.
Interesting. Anyway,
He
sorry.
claimed 4.7.
Yeah.
And as you said, yeah, there was only paperwork from 2004 for 1.9 mil. So there's your first
Yeah.
red flag. The marriage between him and his spouse broke down. And I guess that's when the issues arose, divorce settlements, people trying to exclude assets, what's included in the spouse family agreement. The son tried to exclude $4.7 million from the settlement. And basically what the courts found, or what was found, that there was no repayments being made on this loan, and all of the income that was earned from the assets purchased was retained by the son, so no real debt existed basically, and he tried to appeal that and got rejected again. But basically saying that if you don't make repayments, you can have a loan document, and as we said, there was a document for 1.9 mil. But if you don't make repayments, it's not a real debt.
Yeah. Yeah, and that's the core takeaway, which is probably not new information to a lot of people. But yeah, there's a few pieces there. I mean, firstly, like the timeline is really interesting here, right? Because they're saying that the parents gave the son money, 1.9 million, not an insignificant amount of money, in 2004. Now, he didn't get married until 2018. So 14 years later, and then got divorced in 2021. So they're only together 3 years, right? Um, I found that really interesting that the transaction relating to the parents was such a long time before the divorce. And
Mm.
even if you went from the perspective of sort of the marriage was only 3 years, whereas the property was much longer. Um, and I just one interesting element that then flowed from that. So the total value of the couple's estate at the point of divorce was $7.4 million. So he was trying to claim that 4.7 of that should be ignored because actually he owes that to his parents, which, as you said, Nick, like the court said, well, that's just not, we're not playing ball there.
Yeah.
But it's interesting that actually the final award, the wife got 25%. So there was recognition, like it wasn't a 50-50 split here, right? There was recognition of the fact that he evidently brought more wealth or assets, however you want to phrase it, into the relationship before they got married. So I thought that was quite interesting. Like the way this case study is written is right. What needed to happen is there needed to have been, well, there was a loan agreement, but there needed to have been repayments made, right? Which there never were. Um, and, the judge kind of observes that had the divorce never happened, it doesn't seem that the parents were ever going to ask for this money back, right? So that's fair enough. However, it kind of still worked for the son anyway, because in the end, he got 75% of the total assets, right? So the argument around it being a loan didn't work. But to me, it seems because, like, if the total assets was 7.4 mil and he was trying to say 4.7 of that should be ignored because really I owe that to mum and dad, well, then I don't know. I haven't done the numbers beforehand, but 25% of 7.4, what's that? About 1.4, 1.6, 1.7 mil. It kind of gets you to about the same place as if they had have done the 4.7 and then split 50-50 from there. You know what I mean? So although the loan agreement didn't hold up, the fact that the asset existed before they got married seems to have still, the outcome seems to have roughly got you to the same spot. Did you, I don't know, what
Yeah,
did you make of that?
we're jumping into the legalities here, but if that 4.7 wasn't counted and she still got only 25% of the wealth, then it's clearly much lower than what she did on the 7.4. So, how they came to that 25%, and if they would have come to that with the 4.7 million or the 1.9 million, whatever they supposedly would have excluded from the loan if there was repayments, if it was counted in that way, would have been less. So
I guess it's just like one like this I just find is interesting because I know certainly, when I'm speaking to clients, usually like my clients are pre-retirees, maybe they're even retired. So they're usually the ones doing the lending to the children. And this sort of scenario is always the one they worry about, which is why I'm interested in the other 4 case studies as well, because they present quite different stories. But this is the one that is kind of the headline one, right? I give my son or daughter, whatever, chunk of money to help with the deposit, and then but what if they enter a relationship and then there's a divorce and then my money ends up with the ex-partner, right? It seems to be the one that jumps to people's minds first. And I guess so. Look, the lesson here, okay, if you want to avoid that, do a loan agreement, but then they actually have to make the repayments and you want to track that in a bank account, etc. Okay, cool, like that's fine. But what I found interesting in this one is the courts aren't ignorant of the fact that, okay, well, if one member of a couple comes in with more money, and particularly if the relationship is reasonably short, like in this case, 3 years, the court will recognise that the person with more money, it's sort of, they acknowledge that on the way out when assets get split. They don't just it's not just automatic 50-50 because someone was in a relationship for 3 years when they had assets for, what in this case, 20 years or something beforehand, 14 years beforehand, right? Which just kind of points to sometimes the worry about this particular issue is maybe overstated. Like the other thing to me that sometimes I think about with these ones is, like in this instance, there's no suggestion that there were any children, right? But let's say there were. Well, if you're the parent, then they're your grandchildren, right? Well, would you really want your grandchildren's mother or father to be sort of destitute or, or in a poor financial position? Like, because that's going to impact where your grandchildren live and, their quality of life, right? So, yeah, I just thought this one was interesting in that it ended up 25% to the ex-spouse, suggesting that, yeah, look, loan agreement, maybe that would have avoided some of this, but the courts actually got them to a kind of a pretty similar spot anyway, you know?
Yeah. And
Did you,
they
did
had
you,
that, yeah, they had that loan agreement. So just the regular repayments, or I guess a schedule of regular repayments, or some form of documentation saying there will be or is going to be repayments, might have assisted them or assisted him in that claim. So yeah.
But that's the hard bit, right? Because normally, like if you're helping your son or daughter buy a house, they're normally you're giving a bit and then they're going to get a loan from the bank, right?
Hmm.
And usually, every spare cent they've got is going towards paying off the bank. So very often they just don't have the money to pay mum and dad the loan, right? Like if they had that spare capacity, they probably wouldn't have borrowed from mum and dad in the first place. So I guess this one, if that's the scenario, which is a scenario I see all the time, where mum and dad lend the money and the kid doesn't really have the ability to make regular repayments, then just acknowledge it's a gift from day one. Like, because if you try and do like they've done here, okay, it's a loan. We'll even write it on paper that it's a loan. If repayments don't happen, it's not a loan. The courts aren't going to recognise it as a loan. So maybe you're better off just, being authentic from day one. Your intention was always it was a gift. Like that's usually the case. But just recognise that it doesn't mean, because I do hear this a lot. Oh, but if we just do it as a gift and then they enter a relationship, half's going to go to the ex-partner. Well, this case says no. The ex-partner got 25% and presumably the ex-partner brought assets into the relationship too, because they're quibbling and the loan's 4.7, but the total assets were 7.4. So it doesn't explain what assets that the wife brought in, but presumably it wasn't zero, right? So yeah, I just wonder if sometimes maybe that concern is overstated for some people. Yeah, anyway, I thought that was a really interesting case study, that one, and good to, rather than just kind of theoretically, like if often like we speak to lawyers and yep, you need to make loan repayments, like we've heard that before. The listeners have probably heard that before. But this was actually one that went to court, and here's how it ended, which is the case with all of these case studies, by the way. So yeah, I just thought that was really interesting. All right, do you want me to jump onto case two, Nick?
Yeah, we'll jump into case two.
So this is quite a different version, but I have come across this one before. So what happens here, you've got mother and daughter and the daughter's husband, right? That's the three parties here. And daughter and her husband decide they're going to buy and I think build a house. It's up at the Gold Coast. And so mum agrees to sell her home and chip in basically so that she could have like a granny flat and live with them. And the thinking is like it's good for her as she gets older. She's got her daughter around and son-in-law around to help out and be part of the family and company and all those kind of attractive elements. And I guess, maybe the daughter's good because she can keep an eye on her mum and as she gets older, all that sort of stuff, right? And obviously there's the financial element of, well, the mum chipping in makes the whole transaction affordable. So that's what they put together. Now,
And
the mum...
the important part in that bit is the mum had no legal stake. She wasn't on the title.
Correct.
She just gave the daughter the money
Now,
to buy the house.
it doesn't say it in the article. Why do you reckon they would have done it that way?
There's a couple of things come to mind. If there's a Centrelink age pension element involved at being at age 67, that's when you're eligible for the age pension. However, there are specific gifting rules and what did we say? 270, 470. What did she gift?
Yeah, she gives, it was in two parts, wasn't it? But I think it was, I can't see it in
I
front of me
think
now,
it's
but 270
270.
or something
So
all
that's
up. Yeah.
well above the gifting rules. So that would affect her negatively. Um, so yeah, a couple of things to think about there, or or a eventual inheritance, and not having to wind too much up if
Yeah.
she's the sole beneficiary. So yeah, I guess is a bit unique and a couple of things to consider.
Well, yeah, I mean, I've got to assume it's Centrelink related because I can't
Hmm.
understand why else you would not put your name on the title. It seems odd to me, right? So that's the number one takeaway. But as I say, I do know someone who is in this circumstance, and interestingly, their mum isn't on the title either. So anyway, it's I guess it's just family. Oh, we can all trust one another, and we all love one another, etc. Anyway, in this instance, of course, we wouldn't be talking about it if it all went smoothly, right? So,
Hmm.
so in this instance, it all got a bit awkward, and the daughter and the son-in-law eventually wanted the mum out. Son-in-law was maybe a bit sick of having his mother-in-law always floating around. And anyway, a bit of tension and back and forth. And so they wanted mum back out. And so they offered to give their mum, they offered her 250,000. I don't know why they wouldn't have offered 270, but anyway, 250 to, so she could take her money and she could leave. But the mum wasn't happy about that, and obviously it's wound up in court, which is pretty sad. Um, but in the end, what's happened there is the court's actually given the mum almost 420,000. So she's got all her 270 that she put in back, but they said that um, the intention was that she was going to have a life interest in that property and she needs to be compensated for the loss of her life interest, uh, which is which is quite interesting. So there's 270 that she chipped in, 120 assigned for the value of her life interest, and then uh, an interest allowance of $29,700. So, and particularly when you're part of the, because in the article there's some text messages disclosed here that, I mean, I won't go through because they're a bit long-winded, but the daughter is suggesting that, their marriage is going a bit tough and a bit of tension between the two of them, and having her mum in the backyard was contributing to that tension. Well, boy, I can't imagine after a legal dispute with the mum and then having to give her $400,000 that that's exactly going to be relationship enhancing. So,
Yeah.
yeah, a bit of an ugly one there. What
Bit
what
of
did
an
you
ugly
take from
one.
it, Nick?
Yeah, just on life interest. So the life interest is the promise, or not a contract, but the promise that the mum can live there for the rest of her days and have some form of, security that she'll be able to live in that house
Mm.
forever. I guess as a result of the initial contribution or helping out her daughter to get in there. Um, and what's my takeaway? I guess if she did get $250,000, she probably in the area that they were in, she might not have been able to get anything or live anywhere that she wanted to.
Mm.
So that's why that might not have worked out for her, and it ended up in court where it did. Um, so yeah, there's a bit in that, and yeah, I guess having your going into when you're getting a gift in that manner, you have to have some realization, and you've made that promise, so there is, you're liable to continue with what you've initially promised, especially when there's financial backing.
And it's just, and we see this with some of the other cases too, but it's just so sad, isn't it? Because you
Mm.
can't imagine that at the end of the court settlement, I mean, mum and daughter aren't going to be in a great place, quite clearly, right? Let alone daughter and husband probably not in a great place either. But, with the intention that, oh, mum's going to live with us and we're going to be able to support her in her old age and all that nice. And then to end up, however many years later, presumably, I mean, it would be hard to even know how you'd reconcile after going through all of that. Like,
Yeah. a
God,
lot
what
of
a
there
horrible
was
situation.
well, a lot of the yeah, the first one, the first case we discussed is the son having an issue with his ex
Mm.
spouse. The next ones are all
Within the
mother
family.
and daughter or son. The
Mm.
next ones are father and daughter. So yeah, all of these situations
Yeah.
suck, for lack of a
Yeah.
better word.
Yeah.
And no, yeah, no one wants to think about them, but these are real cases. So
Yeah.
one way or another, unfortunately, it can happen.
And I mean, in each of these cases, and I assume whoever put them together, I assume they're a lawyer or they've got a legal background because the answer in all of them is, hey, you should have spoken to a lawyer at the start. But more what I thought was interesting is just the breadth of different potential ways that things can go awry.
Hmm.
And yeah, this is just a different version of Bank of Mum and Dad, isn't it? It's in this case, mum trying to
Yeah.
help the daughter and her son-in-law purchase a home. They don't have enough money, so she chips in, um, but she gets something for it, right? Which is quite different to the normal loan, or is it a loan? Is it not a loan? In this instance, she gets something for it, but then what happens when they want to unwind that further down? The scenario that I know in this instance, it got a little tricky. There's no tension between mum and daughter, but it got a little tricky when mum then got a new partner
Mm.
and she wanted to go off and do something with the new partner, but how does she get her equity out because they'd anyway that just point being things can get complicated.
Things can get
um
complicated.
yeah. Hey, look, how about we move on to the third one,
Yeah.
Nick, because this
So
is, oh, of all the toxic ones, this is maybe one of the worst.
Yep. So this one again, father and daughter. So John gave his daughter $75,000 to buy a house when she was 18 down at the beach, I believe. He contributed towards renos. He made 1,400 per month loan repayments on her behalf. And then we get down the track and she wants to sell the property. She wants out. And then the father tried to claim 25% equity within the property, and he said that his trust owned 25% of the property. Again, throughout the article, there's text messages, there's, the daughter saying that he's bullied his 18-year-old daughter, his naive young daughter into buying this house and having it in her name for the father's tax benefits. So again, gets real ugly real quick.
Mm.
But at the end of the day, it was deemed that the contribution that he made was a loan and it wasn't equity within the property. So he got paid back his loan and interest. And obviously, as we've already said, a big theme of the article is, getting clear documents, seeking legal advice, and the like. So the outcome was you should have had clear documents to confirm the intentions of the property, to confirm if it was a gift or if it was equity or if it was a loan. But yeah, this one seemed to have gotten real nasty.
Oh yeah, saying that her dad's bullied her, and yeah, it sounded, the text messages on this one were really, really horrible, and there's no way to know, obviously, whose side of the story is accurate. And I guess they're, from their perspective, they're both accurate, depending on how you look at it. But this is almost a flip of case study one in
Hmm.
that here. So there was no formal loan document, but the father's trying to argue at sale that actually he owns a quarter of the property by virtue of the initial capital contribution and then his loan repayments. Um, but the court has said, no, you don't own 25% of the property. All we're going to give you, we're going to treat your contributions as though they were a loan, and we'll give you back your money and we'll give you back the interest, but you don't get a quarter of the property. I mean, they don't sort of share here what the dollar differential is between those two outcomes. But yeah, in this instance, they've ruled there is a loan, even where the dad's trying to argue that there isn't. Uh,
Mm.
oh, man, what a mess. I mean,
There'd be heaps of technicalities that go into why they think it's a loan or why they
mm,
think it's equity. But you'd imagine 75K and then some renovations on top, depending on the scale, and then 1,400 per month of loan repayments on the loan on the property. There's a bit of capital and
I'm
stuff that
amazed
goes
that the
in.
dad was only asking for 25 in the first place because it sounds, I mean, if the daughter was 18 when this happened, she can't have contributed much to the original transaction, surely. Like, it's surprising that the father's not saying, well, it's 75% mine, or, uh, yeah, obviously, there's just not enough detail here. I mean, they're talking about it being for tax reasons, so I assume it was a rental property, but, so maybe, she's paid tax along the journey. Who knows? But, boy, oh boy, what an ugly one this one is.
Yeah. So again, sounds like tax avoidance and him trying to own him trying to claim assets and own assets that aren't in his name. So on top of the court issue with his daughter, there might be some tax issues in there if, depending on what way it was finally
Mm.
determined. So again, quite interesting
The
on a
other
few
instance
facets.
with both this one and the other one, and I'm sure the newspaper article's not getting the full, but the fact that text messages are included in the court case and are given some substance, and there's no documents, but text messages are, well, here's written evidence of what happened. And they're being used as documents. Like, I dare say when these text messages were written, the people writing them weren't thinking that they were going to be used as evidence in court at some point. But that has what's happened in several of these cases. So, yeah, wow.
And those text messages would probably have less weighting. And I don't know, we're not lawyers here, would
Yeah.
have less weighting if there was, again, what they're suggesting, clear documents to say what's what and what's meant to
Yeah.
be for who. And if you do get a 25% equity or you're meant to be paying a 7% interest rate or whatever it is.
Yeah. And it's, wow, just the toxic relationship element. I mean, if the daughter's 18 and dad's right, let's buy a house in your name, and yeah, who's to know? It's totally feasible that it really was, in his mindset, it was always his, and he just put it in his daughter's name for who knows, whatever commercial reasons. But it could have been that, no, look, I'm trying to help you get a start, and but yeah, if he has made, and he's making so not just the 75K, he's making monthly repayments of $1,400 towards the mortgage. Well, that would give you a sense of, well, geez, I chipped in to start with, and then I've serviced the loan over the journey. Surely I'm a percentage of this property at least is mine. That doesn't seem unreasonable, and yet that's not what the court found.
Hmm.
Yeah, wow. It's
Yeah.
again, I mean, like all of these, it just highlights get it documented accurately at the outset. But I can see
Hmm.
why when you're helping your 18-year-old daughter buy a property that maybe that wouldn't. It would be interesting even. I wonder if even if they had have done that, if the daughter, years down the journey could say, well, at 18, I didn't know what I was signing anyway, and yeah, it would.
I think that's what she's suggesting in her
Mm,
text messages there. And I think it goes on to say that she offered to sell it a few times, but she wanted to get her own property and she's already got a mortgage, so her borrowing capacity would be affected. And
mm,
then she might have to compromise because she can't get what she wants. So, yeah, there's lots of things that go into
yeah,
cases like this.
yeah. Super interesting. All right. The fourth one here, another one, right? So here you've got brothers who work together. They own a family fruit shop and they own a couple of shops together, right? So they're obviously the brothers are really tight. They buy a block of land and then they decide they're going to build two side by side units. And in fact, I gather this is a photo of it. It is. So they're joined down the middle, right? So people can envisage it. So they've got a common middle wall, and then there's units either side, a couple of stories. So the brothers have got one each. Uh, they move in, and then I gather it all kind of goes downhill from there. And things get a bit nasty, and I think spouses, maybe the issue. The brothers perhaps get along, but maybe the wives a bit less so. And it's hard when you're living in each other's back pocket, right? Not ideal. So anyway, they're sort of trying to break things down, and the dispute got quite bitter. They were going to sell the property, and then one of the brothers died, 43, dropped dead, and he didn't have a will. So the deceased's wife now she actually claims that she owns both the properties because I don't know, it was a little vague in the article, but essentially, yeah, well, they didn't get it documented accurately, right? So I can only assume that maybe the title was in her husband's name or something. Somehow or other, it seems like they didn't get the title split 50-50. It's a bit unclear. Um, in any event, there was legal battles that ensued, and presumably lawyers made a whole bunch of money um, trying to then get all that resolved. Um, but again, I know through my career, like I've one instance particularly I can think of a business where there's two brothers that run it. Like that's not an uncommon scenario, and where that happens, it's also not uncommon to then, okay, well, why don't we go together and buy more commonly a commercial property, so we can trade out of that commercial property, let's say. And between the brothers, there's just such a trust that it would be easy to, oh, well, we don't have to worry too much about the legals. You just put it in your name or whoever, because the brothers, they're close, they work together, there's just no issues. But I mean, yeah, spouses come in and in this case, passing away without a will, and wow, what a mess that flows from that one. What'd you get out of this one, Nick?
Yeah. I guess, when you're younger, you don't think about wills and powers of attorney and the like, but this demonstrates where, if you've got some assets, and even if you don't, that, a will would make things much easier and might not completely avoid it, but will potentially avoid court battles and fights and whatnot. Wills can be challenged, but you know, it might, make your intentions clear and help your spouse or your brother or whoever out to, confirm what you've agreed upon while you're still here. Yeah. So as we said off the top, it's not a relationship breakdown between brother and brother. I guess another party gets involved, being the spouse, and then that's where an issue arises. And as you said off the top, Paul, a lot of the clients that you speak to around giving money to their kids or helping their kid buy a property, the biggest concern seems to be if this exactly happens with a spouse coming in and mixing up the dynamics, and something happens and one person doesn't like another, and then there's a falling out. Again, don't want to think about it, but it can happen.
Yeah, and like a key takeaway with all of these is as soon as there's money involved, you've just got to speak to lawyers and get it documented correctly. Even though it's family and you trust one another, love one another, whatever, the potential for it to go wrong, and then the the damage that that then does to the family relationship is so consequential that I mean no one likes spending thousands of dollars with a lawyer, but if you're talking about investing hundreds of thousands of dollars, which is the case with all of these scenarios,
Hmm.
it's a cost of doing business, right? You got to pay your stamp duty and you've got to pay certain things to get these transactions done. And you just have to build in that, you know what, we have to pay 3, 4, 5 grand for the lawyers to get it all documented accurately. And if that's not palatable, then don't do the transaction in the first place. Because, yeah, just all the bitterness and harm and yeah, that then flows.
Hmm.
And as you raised, with this one, it also just illustrates, quite aside from anything else, get a will done. Like, if you've got significant assets and you've got a spouse perhaps, and it doesn't mention here, but potentially children too, you've got to get a will. You can't afford, as business owners, especially where there's complexity there, you can't afford to die without a will.
Yeah.
It's an easy one to put off.
Yep. Same with powers of attorney. And again, we're not chatting about estates and wills today, but powers of attorney as well. Because if he suffered a heart attack and couldn't talk and make decisions, yeah, at least if someone could act on his behalf immediately, issues could be resolved if that was the case. The last one here, again, two sisters rather than two brothers, and an investment as well. So two sisters built a duplex to rent out as an investment. So they bought a block of land, built on it, and then with the intentions to rent it out. They had some issues in the building process, and it was incomplete, or there was some works that still needed to be done. So one of the sisters' husbands stepped in, and he claimed that he did 1,150 hours of work on it to get it completed, to make sure it was livable and the like. They wanted to sell it, and there was some arguments, and one party wanted to sell it, the other party didn't. Eventually, they had a falling out, as in all these cases. And then when they eventually did sell it, prior to settlement, the sister or the husband that did all the work on it said that he wanted to claim some money in terms of his labor and the work that he'd put into it, the sweat and tears that he'd made to build this property up. Basically, that was rejected. So they found that labor means nothing in this instance, where it's not financial. It says in there, sweat equity is worth zero without a contract. So it was found that that was rejected, and it was just split as it was initially intended, without any distributions prior.
I was really surprised by this outcome. What did like? I mean, as it's described, the house was built to lock-up stage, but it wasn't completed internally. And then one of the husbands did all the work to complete it, and somehow that got no recognition.
Yeah, there
Like,
was, I think it says there was an agreement that both of the husbands would work together to complete it, but the other one wasn't
one of them
involved.
shirked a bit, presumably.
I guess, you would need a few more details on the case, but if you were,
Yeah, one of
I
them
would
was
be
a tradie and
surprised
one
if you
wasn't.
were,
So I guess the
yeah.
tradies naturally going to be able to make a greater contribution, aren't they?
But if you were a tradie and it was your business to build houses or do plumbing, electrical, or whatnot, it does surprise me that if that was your main mode of business and you put all these hours into this work and you couldn't claim anything, that does surprise me. If you were just a financial advisor and a handyman on the side, I get it, because it's not your main
Yeah.
source of income. But if this bloke was a qualified builder and he got nothing out of it for all those hours he put in, yeah, it does surprise me.
Yeah. Yeah. Anyway, I mean, it is what it is. But yeah, they were talking about $261,000, they reckon, of hours of labor. Uh, and I gather, and then there's a financial contribution of 97, which I'm guessing maybe was the materials. It doesn't really make that clear in the article, but it would make sense, right? If you're installing kitchens and stuff, you've got to buy the materials to do it. Uh, it doesn't really like the financial contribution. Like it says that, yeah, the claim for labor is not allowable, which doesn't say that the financial contribution bit wasn't allowable. So who knows? Maybe they got their money back for the actual materials. But yeah, look, to me, this one seemed really harsh, but doesn't really matter because I'm not the judge. Point being, it's another illustration of, yeah, where, really the one doing the work, I mean, he should have just somehow invoiced and, documented it accurately rather than just, oh, she'll be right, mate. We're all friends.
That's what I mean. If you were a builder or a tradie or something, I mean, sometimes you get an invoice 6 months after the job's complete. So if he had that business and did that as a trade or as a profession, you would have thought that he would have received something from it.
Mm.
Obviously, we're not lawyers, and that didn't happen. So,
But I
yeah,
have
it's
seen other
interesting.
scenarios where I'm trying to think. There was one where, yeah, two people sort of teamed up, but they did have different skill sets. One of them, I think, sort of did all the town planning and got all the permits and did all that sort of stuff. And yeah, the other party was a tradie or something or other and did a lot of the construction. And they worked together. And like that one, to my knowledge, didn't go pear shaped. But the concept of people, and no reason why it couldn't be siblings, the concept of people sort of teaming up and leaning on their strengths, it makes a ton of sense. So, really interesting for anyone contemplating that to know about this case and that actually your labour's not going to be counted. So, so you definitely, it's a repeat of the previous learnings. And as I say, I'm sure that's the angle that this article was coming from in the first place. But see a lawyer at the outset, right, and define all of that and work out how you're going to do it, because just an assumption that that's going to get recognised or that everyone's going to be on the same page. Like it's possible here that the person doing the work just thought, oh, well, that's okay. Like I know they're going to recognize, like in his mind, he might have thought that they were recognizing that. But the people on the other side, maybe, well, clearly it would seem, given they ended up in court, were not thinking that. But an assumption perhaps has been made. Yeah, yeah, yeah. Just so look, as I mentioned earlier, Nick, like to me, I just when I saw this article and particularly just the variety of the different case studies, I just thought, geez, this would be a really good one to share. So, and like the headline is about Bank of Mum and Dad, but actually the final two are not actually Bank of Mum and Dad cases really, but they're still family financial transactions, I guess.
Yeah.
And so they've got that sort of commonality, and clearly the through line of the whole lot is just spend some money on a lawyer at the start,
Yeah.
document it accurately. Because now, like this last one, presumably, I mean, are the sisters still going to be talking? There's a good chance not. So that's the really sad outcome, isn't it?
Yeah, it is. It is. And yeah, all of these scenarios are sad outcomes, basically,
Mm,
from a relationship point of view. But yeah, interesting to dissect because, as you said, we talk about a few of these concepts we talk about. It's very theoretical around you could do this, you could do that, and this may happen in the future. These are people that have lived through these experiences and had to go to court and probably VCAT and all the like
mm,
to get their scenarios sorted out,
mm,
unfortunately.
mm. All right, mate.
But
Should we bring this one
yeah,
into land? What do you
yeah,
reckon?
we will. So that's a wrap for today's episode of the Wealth Builder podcast. Thanks again for Paul for joining me to discuss the article again from the Australian Financial Review. Uh, Thanks everyone to listening along as well. If you like today's episode, feel free to drop us a message or share it with someone you know who might find our conversation valuable. If you did want to discuss anything you've heard from any of our previous podcasts, feel free to get in contact with us via the guidance website and we can help you out. Otherwise, look forward to bringing you the next episode in a fortnight's time. Until then, have a great day.